Dear learners, in the previous video, we ended the discussion by saying that some of the scholars are urging to go beyond the black and white application of the police power doctrine and to shift to proportionality test. So, in this video, we will be looking at how the proportionality test was applied by TECMED tribunal. In TECMED versus Mexico case, we will discuss the full facts of the case and all the issues involved in this particular case in the subsequent video. But for the purpose of this discussion, we will limit only to the aspects of TECMED award which deals with the question of expropriation, right. So, the TECMED tribunal stated that it sort of made an interesting remark. It said that one of the main elements that an international tribunal should consider while looking at the question of expropriation is that it should consider its main job is to distinguish between regulatory measure that was enacted pursuant to the normal exercise of state's police power versus de facto expropriation that may affect the real substance of the investment. So, what we see here is TECMED tribunal is talking about police power as well as it is talking about the effect of the measure on the investment as well, on foreign investment as well. So, first with regard to deprivation, what the TECMED tribunal stated was the deprivation is something that radically deprives the investor to the enjoyment and use of the investment or the investment has ceased to exist. So, it first is talking about the deprivation as well, and then then it goes ahead and states that a measure, a regulatory measure cannot be per se excluded from the question of being an expropriatory measure. That is the first thing it clarifies. Once it clarifies that you cannot exclude a measure from being considered as an expropriatory measure, the second statement that it makes is that TECMED tribunal also stated that host state is in a position to define what are the public policy measures that they can take, what are the issues that they think has to be addressed in order to protect the general welfare of the society. So, basically TECMED tribunal is talking about taking a deference approach because it states that the host state is in a better position to define what is a public policy that they want to achieve and what are the mechanisms or actions that they can take to achieve those public policies. So, this is saying it stated this, first it said it cannot be excluded, second it sort of spoke about a deference approach. Third, the TECMED tribunal went ahead and said nothing prevents the tribunal from examining the regulatory measure if it is a reasonable measure that was taken to achieve the intended objective behind whatever was the intended objective behind the measure. So, basically the TECMED tribunal is also saying that the tribunal has a power to still look at whether the measure was taken, was it a reasonable measure, the regulatory measure was it a reasonable measure and does it achieve the intended purposes as well. So, basically what the TECMED tribunal is trying to do here is it is trying to balance, or while reviewing the regulatory measures, trying to balance between the objectives for which the measure was enacted with the effect of the measure on the investment as well. So, it is clearly talking about the effect on the investment because it goes ahead and makes one more statement. It will consider the size of the ownership deprivation. It will also consider other legal and political factors surrounding the deprivation as well. Why is it considering this factor? These factors is because TECMED tribunal stated that a foreign investor does not exercise any political right in the host state. So, where is this coming from? The fact that foreign investors are not exercising any political rights in the host state, we can go back to the European Court of Human Rights. So, all the cases that were decided in the ECTHR jurisprudence, if we look at ECTHR jurisprudence, we could see that this particular point is also mentioned in James versus United Kingdom case while interpreting ECHR, European Convention on Human Rights. So, in James versus United Kingdom, there was a stress on the particular fact that the foreign investor is not entitled to any political rights that otherwise the citizens of the host state possess. So, TECMET Tribunal also gave emphasis to this particular fact that other legal and political circumstances surrounding the deprivation would be considered. Now, what is the relevance of ECTHR jurisprudence? We can see that the TECMET Tribunal has cited many ECTHR cases. One was James versus United Kingdom, which we just discussed. Then there was Matheus E. Silva judgment, Melcher judgment, then Campanio Rivera Navarra case. So, many cases that were decided by the European Court of Human Rights that was looked at by the TECMET Tribunal. So, these cases, in these cases, the court ideally had to interpret Protocol 1, Article 1 of ECHR, which we already discussed in the previous video. So, a fair balance, the court in these cases said that a fair balance has to be struck between the general welfare of the community at large vis-a-vis the rights of an individual, right to property of an individual. So, while interpreting Protocol 1, Article 1 of ECHR, the courts had given certain, expressed certain considerations, what are the factors to be considered, that was borrowed by TECMET Tribunal. So, this can be the ECTHR jurisprudence can be seen as the basis for undertaking a proportionality test by TECMET. And also the ECTHR in these cases have come up and stated that the host states are in proximity to the actual issues that the society faces, society at large faces. So, deference should be given to the host state while enacting a regulatory measure. So, that aspect that we just discussed in the context of TECMET Tribunal probably comes from the ECTHR jurisprudence itself. Now, one problem that comes up here is after TECMET Tribunal, there were many other cases that had also applied the proportionality test. We can see Archer Daniels, Fireman, we can see LGNE, Azurix. So, there were many cases which had applied proportionality test. Some of them have explicitly mentioned ECTHR jurisprudence like TECMET. Fireman has mentioned ECTHR jurisprudence. Some of them did not refer to ECTHR jurisprudence, but still applied the proportionality test. Now, where the complication here comes is that some scholars question the relevance of ECTHR jurisprudence while deciding an investment dispute. Now, including Ben Mustafa. So, Ben Mustafa also questions how this is not a customary international principle. So, how can this proportionality test be applied in the context of a NAFTA claim? So, that is what Ben Mustafa argues. Some scholars like Dolzer and Schruer had stated that treaty provisions are their own treaty, it has to be interpreted in its own context, not relying on ECTHR jurisprudence. Some scholars have even questioned that this is not pure international law because these cases were decided by interpreting one single instrument, European Convention on Human Rights. So, how can it be considered to be relevant for deciding an international claim that is an investment dispute? There are many criticisms leveled against the application of proportionality test as well, but if we examine, if we analyze if the proportionality test is going to be useful or not, I would say that it still does not solve the problem of unpredictability. In the earlier video, we discussed that Methanex is taking one approach which may not be optimal for investors. Then Taluka was taking another approach which may not be optimal for host state. So, that sort of unpredictability still remains in case of, and the unpredictability that we discussed in the context of sole effect doctrine, you would not know where the tribunal would place the threshold because the line had to be drawn for each case, right. So, that unpredictability still holds in case of a proportionality test because we do not know where or to what extent weightage will be given. We do understand the defect of the regulatory measure on the investment is considered, as well as the purpose of the regulatory measure is considered, but where does the weightage lie, that we still do not know. The proportionality test also does not solve the unpredictability problem that generally exists when the tribunals undertake an examination of or reviews a regulatory measure. So, in the next video, we will look at the suitability of police power doctrine in ISTS, and that will be undertaken in the context of whether police power doctrine is something that should be adopted by the arbitral tribunal while reviewing regulatory measures. We will discuss that in the next video.